let me just, talk about one angle that we have been proceeding here in the Netherlands and Belgium, in the Benelux, and that we will be launching also in France soon, and that is related to binational soldiers who are serving at the same, who are holding the nationalities of these countries, who are Belgian citizens or Dutch citizens, and at the same time, or French, and at the same time are serving in the IDF in Gaza at the moment. So this is for us mainly the let's say the strategic choice to avoid the debates on jurisdiction and also the debates on immunity. Because as you know, of course, I underscore what the other speakers said about the importance of international litigation, and we subscribe to that as such also, and we have been also filing cases at the ICC, and of course we all await the results of the ICJ procedures that were initiated by South Africa. But what we are trying to add to this is a more concrete level of accountability on the national level in European countries related to their citizens who are involved in the atrocities and the genocide in Gaza. And this is a venue that is very efficient in my view, because it allows us to go straight into a debate that is not governed by international law necessarily, and that is certainly not influenced by geopolitics and other balance of power that make, for example, or that could explain why the ICC was very fast to move, for example, against Putin, and is not as enthusiastic when it comes to Israeli war criminals. So when we go into a court in Belgium and we say, as Belgian citizens, we are suing another Belgian citizen who has been committing crimes, this is a total different debate. So let me also refer to the mechanisms of the legal system on the national level that are also different. For example, in some countries, of course, you have to denounce, you have a complaint by denunciation, and then it's the public prosecutor that decides whether to pursue legal action or not, or whether to indict or not. But for example, in Belgium, we have the system that is, I'm trying to translate from French in my head, so if it could be translated into a civil party, constitution of civil party complaints, which means that if I am a victim, or I have been damaged, or I have been, let's say, prejudiced by a certain action of another citizen or an entity, I can press charges, and the public prosecutor is obliged to investigate. So automatically in Belgium, when we are pressing charges, and this is the case that we are working on at this moment, we are preparing. We have already several cases ready from victims, and also we have already several profiles of perpetrators, and all of them are Belgian citizens. The victims are originally people from Gaza who lost their family, who lost property. Some of them have been wounded there. They have been there during the attack, and they now repatriated to Belgium. So direct victims of the genocide. And the perpetrators that we are suing are also Belgian citizens. These are Belgian citizens who are fighting with the Israeli army. So when we press charges from that angle, what happens is that automatically the public prosecutor in Belgium appoints an investigation judge. So there is no debate, there is no political decision, it's automatic. So there must be an investigation by a judge, and eventually the chances of reaching a day in court are much more important than, for example, within the denunciation system that rules in the Netherlands, for instance, where this kind of procedure is not possible. So you see, there are differences between national laws as well. And also in France, we are preparing now a case there, and France has the same system as Belgium. It's not even a choice that has to be taken. It's not a political decision that has to be made. It's an automatical procedure when a citizen sues another citizen with a constitution of civil party. So this is a very interesting avenue, and I think it can allow us to bring the debate, a bit away from the geopolitical, let's say, conundrum that you can experience when you are going to these international venues such as the ICC and even the ICJ. So we are very, hopeful that this will allow us to make it concrete. For example, another element is, and this is related to the immunity debate, we do not have to wait that immunity goes away from anybody, because these soldiers who are Belgian citizens or French citizens do not have immunity. They are citizens. And if they are convicted for genocide, well, the state of Israel is convicted for genocide. Because it's by association in a way. It's being, of course, we try to seek also, not only the genocide crime, but also we file the complaints based on breaches of national law. In some cases, we have also used, for example, let's say the weapon law of the Netherlands, for example, which is very restrictive. And when a citizen of the Netherlands is carrying arms in another country, in a way that can be considered as a breach of the national law as well. So we have to be creative sometimes in order to introduce the cases. But once you are in, then you can also invoke other levels, which can relate to crimes against humanity and also, of course, war crimes before that. So it gives you a different angle when you are pursuing a citizen X or citizen Y, instead of pursuing, for example, Benjamin Netanyahu, who is obviously the main responsible, but who is not easily reachable because of all the diplomatic and the debate around immunity and such. So this is a swifter form of accountability. It will take its time, of course. It has to do, it's a process, but we believe that this is an added value to the collective effort that we are all working on to bring in some accountability to the perpetrators and some justice to the victims.